these things are not that easy. Hello, say hello.
Hello. Hello. Can you be heard? So I really hope everybody else. Yes. Can you?
Yeah. I'll give you the cue. 3, 2, 1, go.
Welcome to the School of Law annual moot court for the law of bankruptcy. We are honored to have you here, and with me are some of our leading judges who are seated behind me. We're going to be having some small introduction for them. I'm not going to take long. I'm just going to be welcoming you and telling you that it's a time to just experiment what it means in terms of bankruptcy law and in terms of facts. So we're going to be having a few teams presenting. There are some who did well on Tuesday, and therefore they're coming today to argue. So please be prepared, make a good presentation, and let's see who's going to be emerging amongst the best oralists, the best team, and the best mood. And see this as an exercise because we've limited the teams to what they're going to be presenting. So it's going to be a small exercise in terms of also helping you highlight what you need to do when you're going to be answering your exams, and you're going to be giving you feedback on the same. So thank you. One of us, the bailiffs, are seated down here. They were former students in bankruptcy last semester. Some of them won, and some of them are working with some of the judges who have come today. So today they have an opportunity to come and also help us in running this court, and they are one of the best cross-examiners. So this in front of me, I'm sure you know her, Brenda. I keep on saying Eden. Brenda is one of us. She also emerged amongst the best in terms of cross-examining, and because of that, she did so well, and she's working with one of the law firms, Stella at the corner, who she's going to be introduced, and she's going to tell us more about her experiences, as well as Lennox, who is also done well and is working under SOC law, which is Sospita, and is going to tell us how his experience has been under SOC law and Africa Health Law, as well as Pride as well, who is working under MMMW. I'm sure you see some of this. The rest on this side, it is not by arrangement, but by default. They're all former students of Jkuat. We should be proud of them. We should welcome them. They're wanting to give back. We have Edwin. He's also having his own law firm, and he's been in practice many years before he even began teaching here, and he did his, and he's been in practice and he's doing a lot, and we're going to tell you more, as well as Dachi as well. He's an associate in one of the leading law firm, and in fact that law firm is very young. They finished Kenya School of Law with us, and they're also leading in the field, as well as Max, who is just about to finish the university and has some wealth of experiences. They're going to be introducing themselves, and our seniors at the far end is
because I think I was the best cross-examiner or something, and I went ahead to work with one of these judges who I'm introducing. Her name is Madam Stella Mugaburi, my boss, a feminist. She's a tax lawyer, an insolvency practitioner, competition law, corporation law, and she's a senior managing partner at MMW, which is going to be one of the biggest female-led law firms in Africa. She has 25 staffs, and it has international reach in Asia, Europe. It's a big firm. You should make sure you network with her. She has worked on high-profile cases like presidential petition in 2013 and other election petitions. And most of all, and she does legal articles, which I urge all of you to go check out on LinkedIn. So that's Madam Stella Mugaburi, hand. I think they'll talk to you after, not right now. Next here is Mr. Sospita Aminga, co-founder and managing partner at Soklo. He has over 12 years experience. He's married to a woman and has 4 kids. Married for 11 years, may I say. You should think about it. And he is saved. They both graduated from UN. He has worked at KTDA when he was in second year. And then he went ahead from 2009 to work in the insurance sector. So he has expertise in insurance matters. He's also a certified public secretary, which is, as he said, a good supplementary course for law. His areas of expertise are commercial, civil, and he does criminal actually for free, so make sure you network and call him sometime. Yeah, he's a good litigant, and those are the 2 senior counsels here. Thank you.
A round of applause. Thank you for that introduction. Now the next great person I'm going to introduce is coming from this institution itself. You know, many people say that Jkuat has not put itself actually on the roadmap, but that is not true. If you take a keen look at Edwin Dichu, he's a very good litigant. And as you all know, by virtue of Article 31, the legislature actually made the Data Protection Act. Now, if you follow landmark ruling case, because we are saying that as lawyers, it's not your work that should introduce you, but rather the experience and the work that you've done. He has a landmark ruling case that actually happened this year, which most of you will follow. It was between Hilda Kamande versus Nation Media. It involved image rights. And I do believe that most of you have done intellectual property. So you are very familiar with the idea of privacy, the idea of consent, and the idea of damages arising out of misuse of a person's right to privacy. He handled that case, and he actually won it, and the person was given around 2-3 million for the damages. Now, he has worked with various departments, including, but not limited to, the county government, manufacturing companies, and even institutions of higher learning. I have never met him before I came here. I was actually, but he's a very good person and a friendly person, and I'll urge all of you to take a minute before you leave this room today and actually get his number, because even if you don't get internship, you don't get a job, the main thing is that you build, because there is no lawyer on this planet that knows everything, and each and every day is a learning experience. So therefore, this is Edwin Dichu. He'll introduce himself later on after you presented your cases. A round of applause.
Good afternoon. Good afternoon again. My name is Brenda Nyaega, and as indicated in the posters that were shared, I also work with Madam Stella, and today I will be introducing one of our judges as well as acting as bailiff. So we have the pleasure of Robert Dachi. He will be one of our presiding judges. Robert Dachi is an advocate of the High Court of Kenya. He is also a member of the Chartered Institute of Arbitrators. Notably, he was a former student of Jkuat from 2012 to 2015. It is also important to note that he is a very ambitious commercial dispute resolution lawyer, and this reigns apparently in the matters that he has handled. It's important that I also let you know that his favorite quote is that be the best in everything you do. He is also keen to state that hata kama ni sherehe, be the best in everything you do. A hand, can you please?
All right, everybody. Introducing a student who is currently still here, but at least I have the privilege of doing that, and I'll be doing the same thing for you. You know, you're seated here right now, but you're going to be my future colleagues. But you have Max here. He just came to me on Tuesday and said, Madam, can I be a judge? I was looking at him, I was wondering who. I had invited people already, but then he proved himself on Tuesday, and that's why we've come with him today. So a round of applause. That's what I encourage, and that's why we're here for mentorship, and that's why the judges are able to spend their whole afternoon here with you. So Max, he's working currently at Jubilee Insurance, just like Sospita. He said from second year he started working with KTDA, so he's following that footstep. Formerly, he worked with the National Law Commission, Law Reporting Commission, and he was also an intern at HHM, Dentos Limited, and even Crew. So you can see he's not yet finished fourth year, but he's done all these things, all right? And you know our mentorship is about mentorship from book smart to street smart. So you need to start early, like the way we are giving you opportunities today. And then he has many accomplishments. I was also surprised when I looked at them. I don't know how many of you have done moot. How many have done moot before? By a show of hands? Just a few? How many this is your first time in a moot? Kind of? Okay, so for Max, guess how many he has done since joining Jkuat? 20. He told them. He has done 21 moot courts since he joined Jkuat, all right? And he has won 13 of them, all right? Have you gotten certificates for them? Yes, and he has gotten all those credentials, all right? So if you're going to Stella, or Madam Stella, or Mr. Sospita, or Edwin here, Mr. Edwin, or Dachi as well, you're coming, all of you are seated down here. It's survival for the fittest out there. If Max comes in, he has all this number of moods, he has all this number of experiences, and you've come, you've not done anything, who would you like to choose? All right? I'm just trying to encourage you to engage in extra. So you just say, even if you've not done 21, at least you've done today, right? You've also done on Tuesday, so you put it in your CV. Hata kama uko best, some of you are going to be in the best winning team. Uandike tu kwa your CV, part of the winning team. I prepared submissions of this, all right? So every small thing counts. So Max has done that, and then I'm even surprised, I think I was sleeping when I was in university. He has co-founded the National Sahara Law Club, all right, which registered 8 faculties of law nationwide, and what he's doing there, doing debates, and they're writing precedents on law. So hata kama unaanza kidogo, hata kama wewe ni hustler, I like speaking Swahili, I'm teaching you bankruptcy so you know me. Sasa kama wewe ni hustler, Ruto alisema sisi ni hustler nation, Max ana hustle hivyo. Pia wewe fikiria hustle yako mtaani itakuwa namna gani, all right? So just this is, even if you've done this is your first time doing moot, one of us was saying they don't know about public speaking, we have the judges here to talk about it, all right? With that long introduction, let me finish with 2 quotes. Max is a Christian, I think, and Sospita has said he's also born again. Ameongea kuhusu David. David akauliza Mungu, shall I pursue after this troop? Shall I overtake them? And he answered them, pursue, for thou shalt surely overtake them without fail or recover. So you guys, when you're pursuing your education, I'm not going to teach you again. I think this is the last class that I'll be teaching. I don't teach 4th years. So pursue. Whatever you want to pursue it diligently. Felix was congratulated for cross-examination, all right? He decided, even if his team, did your team win to the last round? He did not win in the last round, but he emerged amongst the best. So even you, pursue, all right? And we can say the last thing is, Nelson Ashitiva is one of the leading law firms in Kenya. The dream of every generalization lies in the pain of that generalization. Dare to dream. So dare to dream. There's pain I'm sure mnafikiria exams next week on Thursday. At least most of you, at least when you see your cut from Tuesday, all of you got 6 and above out of 10. So at least ukona 6 out of 100, all right? Or 7 or 8 out of 100, all right? So you're going to be having your written submissions by next week Tuesday, but I want you to at least also, apart from book smart the way you are, also become street smart, and our judges are here to encourage you on that, all right? So thank you very much. I think you can go to the next round. We're about now to go to the next main thing, which is the student presenting, then we'll wrap up in the last session, all right? So over to you, Leonard.
Thank you for the good introductions. Now, I don't talk too much because the day was not meant for me to shine, but rather you participants. So therefore, I'd like to remind you of somebody great that I think all of you have heard about. It's called Charles Darwin. So all of your participants, yes, you are learning, but you have to emerge with a winner, right? So do your best as you present. I myself don't know who's going to win. The judges don't know. So it's up to you to decide. Now, the matter before this court is the bankruptcy petition number 10 of 2022 before the High Court Division, the High Court Commercial Division. Preliminary objections or any issues will be decided by the judges, including but not limited to matters of evidence. Thank you. Is there any direction from the judges?
Welcome everyone. You are presiding judge for this court session. As you heard from one of the bailiffs, Mr. Speaker, together with my colleagues who have also been introduced. And without wasting any more time, we begin with the data side. The data side.
All right. I'd like to raise a preliminary objection as to the statement of facts. It is evident that under Section 15 of the Insolvency Regulations, it clearly states that an application for a bankruptcy order must be preceded by a statutory demand. However, if you look at paragraph 5 of the statement of facts, it clearly states that Kasukun cohorts with the friends above filed a petition against Sonko for the recovery of certain sums. Now, if you look at paragraph 4 of the statement of facts, there were contracts listed and the petitioners were demanding the sums. However, you can see clearly here in the statement of facts, there's no evidence of a statutory demand, and that is what we are objecting to. There must be a statutory demand which was initiated by the petitioners in this case, according to the statement of facts, relying based only on the statement of facts. That is our objection.
Sorry, you didn't introduce yourself.
Yes.
My name is Shalom Omondi, lead counsel. Yes. Shalom Omondi, lead counsel for Mr. Sonko.
Perhaps before you continue, you can introduce your team for the purposes of judges recording.
Can you please this court? Good morning. Good afternoon. My name is Shalom Omondi, lead counsel for Mr. Sonko in the bankruptcy petition number 10 of 2022. Here with fellow co-counsel Mushai Collins and third co-counsel Caroline, representing Mr. Sonko, the debtor.
Caroline who? Caroline who?
If you take this records, I would like to remind one of the clear guidelines is no mobile phone for any participant or any electronic device unless the judges will allow for that.
response from the creditor's side. There is a preliminary objection that has been raised by the debtors' counsel.
May it please this court, my name is Peter Mogoba, and I believe that you are making independent submissions.
Do you have any response to what he has raised?
Independent submission. So if he's making an objection, it means he's making an objection independently as the debtors. I don't think by the guideline given by Madam Simi we are supposed to respond to that.
I'm merely relying on the statement of facts. No submissions were given, and this is part of the independent submissions. We are both relying on the statement of facts, and as such, I'm just raising a preliminary objection as to the order and nature of the petition, the procedural requirements. There is no statutory demand for the statement of facts.
Mr. Mondi,
Yes.
you have a copy of your, what do you call this? The grievance.
Yes, pleading.
You have this application. You set aside a statutory demand
Yes,
that you have filed.
yes.
What were you setting aside if you indicating that there is no statutory demand?
Thank you for that question.
Yes.
Our pleadings were merely an application in the civil magistrate's court because the previous debtors had made an application, an erroneous application in the civil magistrate's court to which we had applied. We had applied a motion of notice to set aside, to dismiss this application in the civil magistrate's court. But mine is merely on the statement of facts alone, which takes precedence over any submissions.
Mr. Mugoba, can we introduce you, I think?
May it please this court again, my name is Peter Mogoba, lead counsel for the petitioners. I, together with my co-counsels, Collins Owino, Diana Massis, represent the creditors who are the petitioners in this case. My lords and my ladies, we submit indeed that this court has jurisdiction and the capacity to hear this matter as per Article 165, sub-Article 3 of the Kenyan Constitution, that the High Court has unlimited jurisdiction to hear both civil and criminal matters.
Mr. Mugoba, I am particularly interested in jurisdiction in this matter. The matter was first filed before the magistrate court. Why should this court listen to a matter that is live before another court of competent jurisdiction?
My lords, according to our submission, you can clearly see that we filed the matter in the High Court. The petition is in the High Court.
Good afternoon. May it please the court. For purposes of clarity, we're making independent submissions in the sense that they have their own submissions after you gauge them on their mastery of the bankruptcy proceedings, on the mastery of bankruptcy provisions and all that. After which we will make our own individual submissions.
Think on their feet to the back.
Okay.
So we challenge them to think on their feet. They have not prepared anything.
Now we are not proceed, my lords. Lords and my lady, bankruptcy is a tool and not a badge of shame. Due to these circumstances, my lord and my lady, the petitioners have been forced to lodge a petition in this honorable court. For the creditors have suffered independently because of the amount of money we are owed.
Sorry, Mr. Mugoba, just to take you back on the issue of jurisdiction.
Yes.
I'm seeing the sum claimed by your clients is 6.7 million, yes? Why does this court have to hear this matter when it falls under the pecuniary jurisdiction of the magistrate's court?
My lords and my ladies, Section 17 of the Insolvency Act, read together with Section 2, describes what court should listen to this kind of petition. And it clearly states that the court in Section 2 of the Insolvency Act clearly states that this court has the honorable jurisdiction to hear this matter.
Just the same matter that the senior has asked you, Mr. Mugoba. There is an aspect of contract of service between your clients and the debtor, right?
Yes.
which actually qualifies an aspect of employment for a short term of period, right? So why should the High Court hear a matter that is a reserve of courts established under Article 162.2?
Sorry, my lord,
Article 162.2 creates the employment and labor relations.
Yes.
And you have admitted that there is an aspect of employment in the matter by the fact that there was a contract of service between your clients and the debtor, right? So why should a reserve of the employment and labor relations court be heard before the High Court?
My lord, I presume this is a bankruptcy matter.
Proceed.
And my lords, may I start that bankruptcy is a tool, not a badge of shame. And as a result of these circumstances, the petitioners have been forced to lodge this petition in this honorable court. And my lords, the petitioners are owed a significant amount of money, and that is why we are here in court to claim the amount we are owed. And we are claiming that justice might be served by this honorable court. My lords, my counsel Collins Owino will be dealing with issue number 1, whether the debtor has the capacity to pay the debt, while my co-counsel Masis will be dealing with issue number 2 and number 3. Issue number 2, whether the client or the debtor complied with the requirements to set aside the statutory demand, and issue number 3, whether the debtor committed any bankruptcy offences. I'll yield because of time, I yield the floor to my first counsel.
Greetings, members of the bench. My name is Collins Owino. As I introduced, I shall be speaking to whether the debtor is indeed at a capacity to pay his debt and consequently seek or receive this court to issue a bankruptcy order. My lords, I shall rely on Section 17 of the Insolvency Act and the Insolvency Regulations. My lords, Section 17(2) of the Insolvency Act speaks to whether the creditors may apply for a bankruptcy order, and it has given us 3 thresholds: 17(2)(a), B, and C. 17(2)(a) speaks to the prescribed bankruptcy level. Regulation 3 of the Insolvency Regulations states us that the prescribed bankruptcy level for all other bankruptcies shall be 250,000 Kenyan shillings. We submit to this court, as per paragraph 4 of the fact sheet, that the debt owed by the debtor is a total, cumulatively, is a total of 6.7 million Kenyan shillings, and as such, then it exceeds the prescribed bankruptcy level.
Counsel, Regulation 15 also requires that when you're filing the petition, you accompany to the proof of debt. Where is the proof of debt?
Indeed, much obliged, we supplied the court with the proof of debt. Yes.
Sorry, Mr. Owino, before you proceed, are the debts considered as cumulative or individual debts?
Much obliged to you.
Regulations.
Much obliged to your question. My lords, I rely on the case of the Invesco Assurance Company Limited versus Damacharo and 57 others. The applicant, who was the debtor, told the court that several debts in the statutory demand did not meet the bankruptcy level. The court stated that cumulatively, the total amount of debt that the applicant had owed surpassed the prescribed bankruptcy level.
Absolutely. Sorry, I'm presently the Invesco case. That was a debtor-initiated petition.
Yes.
How does that deviate from this petition? This is creditor-based, a petition by creditors. So is it proper for a creditor to present a proof of debt individually, or it's supposed to be considered cumulatively?
In our case, we presented the proof of debt cumulatively for all the 7 petitioners. My lords, Section 17(2)(b) speaks to whether the debt is payable immediately, unsecured, and whether the debt is payable immediately, unsecured, or over liquidated amount. We submit to this court that the creditors in this petition are unsecured creditors. 2, the debt that was owed by the creditor is over liquidated amount of 6.7 million Kenyan shillings. Lords, as per Section 17(2)(c),
when can someone be judged bankrupt? When is the individual judged bankrupt?
An individual is judged bankrupt when the court determines that the liabilities indeed exceed the assets that he has.
as per the time they are due to be paid.
Yes.
Well, so why is Mr. Ted Josiah creditor in this petition?
My lords, as per section 2 of the Insolvency Act, the meaning of a creditor is that the debt that is owed by Ted Josiah, who indeed aver that the debt was supposed to be paid on August. However, upon the court coming up with a bankruptcy order, or rather issuing a bankruptcy order, Ted Josiah shall and will be required to be paid, and as such then will saw it fit to add him as part of the petitioners. Similarly, section 17.2b speaks the debt being payable at a certain future time, and we have relied on that section 17.2b to ensure that Ted Josiah's debt is payable at a certain future time, that is on August 2020. Lords, on the part of whether the debt appears to be unpayable or the debtor has reasonable prospect of not paying his debt, we shall rely on the statement of facts, and we seek this court to also rely on the evidence that have been annexed in this court. The evidence that have been annexed, that speaking to the bank statement and the financial, the bank statement and the statement of affairs of the creditor. My lords, taking you through the fact sheet, my lords, Sonko received a contract from Kusota Limited for 5 million Kenya shillings to arrange an event called the Lovers' Day event on the 14th of February 2021. The immediate reaction of Sonko was to take 2 million and pay one of his creditors. We are not aware of the other creditors that Sonko had, but we are aware of one creditor called Wanamkali, 2 million Kenya shillings. Further, Sonko spent 300 Kenya shillings to take his wife to the Maldives. He also spent 700 Kenya shillings from the money that he received from Kusota Limited to buy the mistress Kasupu a Vitz worth 700,000 Kenya shillings. My lords, from the facts you could see that Sonko did not spend any of his finances. The finances that were spent were the finances that he received from Kusota Limited. And my lord, as per paragraph 4 of the fact sheet, it is a usual practice of Sonko to take things on credit. My lords, by that simple fact, we say to this court that indeed Sonko is not someone that is capable of paying his debt, as he had relied on the money that he received from Kusota Limited to actually offset some of his liabilities. Further, my lords, to the evidence that have been annexed to this court, and I shall speak specifically to the bank statement. My lords, the bank statement in this, my lords, we submit to this court that the bank statement that has been adduced to this court is unreliable and inadmissible. This is coupled by the fact that Sonko in the bank statement avers that indeed he received money from the creditors. We are not of the same position. Sonko only entered into a contract with the creditors. That means that there was no money received, and as such, the bank statement then does not show the clear proof of the clear proof of the transaction that Sonko had entered into. My lord, irrespective of the question that you take in regard to the bank statement, a bank statement is not sufficient proof to prove that indeed you have money or not. With that, my lord, I seek to seek the floor to my co-counsel to submit on the issue of statutory demand.
What's the conclusion of your counsel?
The conclusion of my argument is, one, we are inconsistent with section 17.2 of the Insolvency Act. That is in regards to one, the prescribed bankruptcy level. Two, whether this debt is payable immediately or at a certain future time. And three, that we have submitted to this court that Sonko is indeed not capable of paying this debt. My lords, you would agree with me actually under section 20 of the Insolvency Act. The court may only dismiss the petition if it finds that indeed Sonko is capable of paying his debt, or if Sonko has entered into agreement with the creditors. One, there is no such agreement that was entered there's no such agreement that Sonko has entered into with the creditors. And two, Sonko is indeed not capable of paying this debt, and has been shown by the mere fact that the bank statement and the statement of affairs that have been adduced to this court do not specifically show us that indeed this person is not indebted. My lords, from the facts too, my lords, Sonko does not use any of his monies to actually do all the things that he has to do. He actually spends the money that he received for the contracts under Kusota Limited. Thank you, and I cede the floor to my co-counsel.
Good afternoon. May it please the court. My name is Diana Nassis, one of the counsel appearing for the petitioners in this case. I'll handle issue 2, which is whether the right procedures are followed in setting aside the statutory demand, which directly correlates with the fourth requirement that gives a creditor power to bring an application or petition to court to adjudge one bankrupt. And that is that an application to set aside a statutory demand ought to have been sent to court. However, this was not done. My lord and my ladies, subject to Section 17(3) of the Insolvency Act, we, the petitioners, made a statutory demand and sent it to the debtors via a letter dated 23rd of May 2022, demanding for the debt that was due to us. However, it was not complied with, and neither did the debtor make an application to court to set aside the statutory demand. My lord and my ladies, Regulation 16 of the Insolvency Regulation provides for the procedures of setting aside a statutory demand, an application to set aside a statutory demand, and it says that a debtor, upon receiving a statutory demand, either by being served or coming across it in any newspaper, ought to make an application to court to set aside a statutory demand or comply with it before the lapse of 21 days. Further, Regulation 17 of the Insolvency Act provides that the court, upon receiving such an application, may either dismiss such an application if it deems that there is no reasonable cause to grant the application. That if the court fails to dismiss it, then it will grant a hearing notice within 7 days to both the debtor and the creditor. And the creditor will be given an opportunity to respond within 3 days to the hearing. That the court will grant such an application only if the debtor shows that he has reasonable capacity to pay the debt, that it is justifiable, that he has a cross demand that is either equal to or greater to the debt that is due, or that the creditor has a security in respect of the debt that is either equal to or greater to the debt that is being demanded. My lord and my ladies, it is very clear that no application was made to the court to set aside a statutory demand. My lord and my ladies, I refer you to Section 17 2C and Section which states that a debtor will be considered to be under no reasonable capacity to pay his debt, and marrying it with Section 17(3) and Section 17, if a statutory demand is set and it is not complied with within 21 days. I'll also refer this court to the case of Flower City Limited versus Polytanks Containers Kenya Limited, course number 33 of 2021. In this case, the applicant had made an instant application to set aside a statutory demand that had been issued against him. Yes. Yes.
You take away the 700,000 that bought the goods from his Kasuku.
Yes.
And you take away the 900,000 that was supposed to be paid to Ted Josiah as it falls in.
Yes.
And then, for example, the debtor raises a counterclaim on the invoice for the rest of the debts.
A counterclaim?
Yes. Because you have said under Regulation 17(6) that an application to set aside a statutory demand can only be granted if, for example, the debtor raises a cross demand account.
Yeah, a counter demand.
Yes.
Much
So,
applied.
yes. So we take the 900,000 cancel from the 6.7 million. How much do you have left?
5.7.
5.8 actually.
8, yes.
Okay, we take out the 700,000. How much do you have left?
We cannot include the 700,000.
Okay.
Yes.
Enlighten me on that.
Okay. Now, a cross demand means that the debtor, that the creditor has a debt in regards to, or rather the creditor owes a debt that it supersedes the debt that is due from the debtor, in the sense that the creditors had a 6.7, or rather more than 6.7, owing to, that is owed to Mr. Sonko. That's what I mean. In the sense that Mr. Sonko can come and claim that the creditors owe me 6.7 or more.
My math is the same.
Yes.
Just quickly, in your solution is that the 700,000 that reads, for instance, was under the debtor's own credentials. The goods was bought by the debtor's money and is under the, because there's a similar in the bills from the debtors, that the logbook of the REITs actually falls under the name of Mr. Sonko.
Yes.
And the 900,000 of Ted Josiah is yet to follow you.
Yes.
And for the rest of the debts that are remaining, you require an invoice to show proof of debt, which the council has rightfully submitted that are in the bills.
Yes.
So should the court go through the bills and find that the counterfeit shows that the debtor actually has a claim on the creditors that equals or supersedes them, and this court can grant that application, right?
No, it cannot do that because the debtor owes the creditors 6.7 million. Now, in regards to the amount owed to Ted Josiah, which is due on 15th of August, that amount, yes, it is supposed to be paid on 15th of August. However, under Section 2 of the Insolvency Act, it describes a debt as including either a future or a present debt. Thank you. Now, in the case of Flower City Limited versus Polytanks Container Kenya Limited, Insolvency Cost number 33 of the Insolvency Act, the court stated the essence of a statutory demand by a creditor, and that it is an essential element in the sense that it is a test of solvency, in the sense that if it is not complied with within 21 days, or rather there is no cross demand, then the debtor will be considered to have no capacity to pay the debt. I'll move on to the third issue in regards to whether any bankruptcy offences were committed. It is our submission that certain acts were committed which amounted to bankruptcy offences contrary to Section 289 of the Insolvency Act. Now, these acts must be committed either before or after one is adjudged bankrupt. And in ordinary cases, it may not be considered an offence, but if it materially leads to if it materially contributes to the debtor being bankrupt, then it's considered an offence. You buying yourself a very expensive car is not an issue, but if it materially contributes to your insolvency, then that is an offence. I'll address the instances when these offences were committed. And the first one is that of hazardous speculation. Mr. Sonko is known as the CEO and owner of various chains of companies. Therefore, he is expected to exercise due diligence by ensuring that he organizes the event and then use the surplus to deal with his own personal things. But I see Mr. Sonko going ahead and going to a trip in Maldives for 1 week with a wife, using part of the money to buy a car for his mistress, using part of the money to offset his personal liabilities. This is an offense because he's taking risk with a business mind. Further, he also committed certain acts such as living extravagantly and unjustifiable spending as indicated by the acts that have presented before this court. My lord and my ladies, we therefore, as the petitioners, pray that the court finds that the debtor is at a low capacity to settle his debt and therefore declare him bankrupt. That the court declare that he committed certain acts that amounted to bankruptcy offences, and that the court be pleased to appoint a bankruptcy trustee. My lord and my ladies, to conclude, although bankruptcy proceeding is considered a draconian step, however, in the case of James Minor Kabatha, the court stated that the twin goals of bankruptcy proceeding is first, to protect creditors and ensure optimal payment where possible. The other one is to provide a shelter and a fresh start to individual debtors overburdened by debt. But yes, I'm about to. However, as indicated before this court, he's not an innocent debtor. He's a fraudulent debtor and a crafty one. However, he still has a second chance in the sense that he will be able to have a fresh start after being discharged from bankruptcy. My lord and my ladies, further, he's provided protection by the bankruptcy laws, that his tools of trade will not be taken away from him, and further, that he will be left with a reasonable amount for his upkeep and that of his family. It is only in the interest of justice that this court finds that Mr. Sonko is bankrupt and that we are able to recover that which we can from his assets. Thank you.
Council, kindly before you begin, the creditors utilize 20 minutes. In the interest of justice, will also be accorded 20 minutes unless stated otherwise by the bench. Kindly share with the court how you utilize the time between your other court.
Please, the court. Good afternoon. My name is Shalom Mondi, lead counsel for Mr. Sonko in the bankruptcy petition number 23 of 2023. I will be taking 9 minutes to deliberate on the first two issues as to whether or not the debtor has capacity to pay his debts and whether or not he should be considered bankrupt. The second co-counsel, Mushai Collins, will be taking 7 minutes to deliberate on the third issue as to the position of the first and sixth petitioners in the case, and also adding on my points as to the capacity of the debtor. And the third co-counsel will be taking 5 minutes to argue matters of procedural order. However, in the interests of Article 50 of the Constitution and in review of our pleadings, we would further again like to reiterate the matter of the jurisdiction of this court and call it into question, being guided by, as a result of the actions which were taken by the creditors, as you can see when they filed the case in the Civil Magistrates Court. It is within our position as the debtors to stipulate before this court that a matter which is present before another court cannot be heard by another court as stipulated through the doctrine of sub judice. Now, it was narrated in the case of Ri Budiala Javraji, a 2015 ELR case, which stipulated that in regards to the withdrawal of cases, it was held that leave should be granted within the law upon considering the grounds adduced by an individual and whether or not they should be justified. Now, members of the bench, we do not dispute the right of the creditors to withdraw from a case, as was stipulated in the case of Daniel Dixon Bravo. However, we reiterate before this court that such withdrawal must seek the leave and permission of the court. And as such, we had stipulated in our submissions that the creditors had not serviced us with any evidence of that withdrawal from the magistrate's court, and therefore we argue that this matter is sub judice. The guiding principles for a matter being sub judice was reiterated in the case of Kenya National Commission on Human Rights versus AG, where the court stated 4 essential principles. Number 1, there must be more than one case with the same matters being litigated. And number 2, both suits must be pending before the courts. And number 3, there must have been a previous suit that was filed before this current suit is present in this court. And lastly, number 4, the suits must be present between the same parties. We therefore reiterate that the matter which is before this court is sub judice, and we ask the court to consider our submissions in our pleadings in making the decision before we proceed with the matters of this case. Thank you.
What's the jurisdiction? In which court should a petition like this be filed?
Thank you for your question, Your Honor. Under the Insolvency Act, it clearly stipulates that a bankruptcy petition will be heard by the High Court. However, we reiterate again that the creditors, the petitioners themselves, had filed erroneously this bankruptcy petition in the magistrate's court and then sought to withdraw the case without the leave of the court. Now, it is essential to note that leave must be granted by the court before taking it to another court. And therefore, we reiterate that the matter which is before this court is a matter of sub judice. And before moving on with the substantive matters of the case, we ask this court to determine whether or not this matter can be heard before it.
Is it your argument that the magistrate court also has jurisdiction to hear a bankruptcy petition?
Thank you for your question. It does not. However, it has the requisite power to grant leave upon application of withdrawal of any case from it, regardless. And this has been reiterated in the case of Budia La Jivraji, a 2015 EKR case. There must be leave from the court before it is taken to another.
What is the effect of filing the petition in the wrong court?
The effect?
Is there a case in the first place?
There is no case. Thank you for your question.
So if there is no case in the first place, do you still insist that this petition is subject?
Thank you for your question. What we are insisting is the issue of withdrawal and consent and leave. There was no evidence of permission granted by the magistrate's court. That is what we are reaching before this court, and therefore the petitioners had to get and seek the leave of the court before filing it before the High Court.
It's the position of the debtors that we need to learn our jobs. That's what you're saying.
Thank you for your question. It is within our position to state that procedural order must be followed with, regardless, and that even if this matter, it is our position that procedural order must be followed with regardless. We do take into consideration Article 159, 2D of the Constitution, that justice shall be administered without regard to procedural technicalities. However, such should be read in line with Article 22.3D. Such procedural technicalities must be reasonable. And therefore, we iterate that this is an unreasonable error, and therefore this matter should, the petitioners must seek the leave of the magistrate's court before taking it to this court. That is our position.
So does this court has power to transfer proceeding that is ongoing in a magistrate's court itself? Can this court allocate itself that jurisdiction?
Thank you for your question. Yes, it can.
Proceed.
Proceed with the substantive.
Yes.
Thank you. Members of the bench, the reason why we are before here today is due to our client, Mr. Sonko. Now, in the statement of facts, it is clearly seen that Mr. Sonko is a CEO, a businessman, a family man, but we reiterate before this court, Mr. Sonko is no debtor. And we would like to provide the reasons as to why. Now, if I may use one of the quotes by the petitioner, who clearly stated that bankruptcy is a tool and not a badge of shame. And we are stating before this court that Mr. Sonko is in essence being shamed before this court by being brought for matters which are under his control. Number one, the petitioners claimed that Mr. Sonko did not have the capacity to pay his debts. Now, if we go to Section 17 of the Insolvency Act, it clearly states that an application to a judge, an application for bankruptcy will only be entertained by the court if the debt or each of the debts is a debt that the debtor appears either unable to pay or to have no reasonable prospects of being able to pay. Members of the bench, a statutory demand was sent to Mr. Sonko, to which the demand reiterated that he pay the 6.7 million Kenya shillings due, and that he pay it within the requisite time, or else there would be a petition to judge him bankrupt. However, if you look at our pleadings, we clearly show that an offer was sent to Mr. Sonko, to which was unreasonably rejected. And if you go to Section 20 of the Insolvency Act, it clearly states where a debtor makes an offer to secure or compound any of his assets, then the court may dismiss the application to a judge that debtor bankrupt. And therefore, we reiterate before this court that we do have the capacity to pay, we are not insolvent, and that this court should not adjudge as bankrupt.
Should Section 20 be read disjunctively or cumulatively? Because it sets out 3 grounds.
I'm sorry?
The section that was quoted, should it be read disjunctively or conjunctively?
Should be read conjunctively.
So, if, for example, the unreasonable aspect of it with the creditors is the only mess, yet Sonko is unable to pay and there is no reasonable offer that has been made, and the rest qualifies this court to adjudge the client. Is that your position?
Thank you for your question, Your Honor. If I may take you back to Section 20, subsection 3 of the Insolvency Act, when read in conjunction, it clearly states that the debtor has made a reasonable offer. That offer has been unreasonably refused, and if the offer had been taken, then there would be no bankruptcy petition. And as such, when taking a look at all of the 3 clauses and going to the offer that was made, we reiterate before this court that it was unreasonably rejected, and that we had every capacity through Sonko Limited and the VITs, which is registered in Mr. Sonko's name, to pay off our debts. And that is our position before this court, that we have the capacity to pay off our debts, and that such capacity has been shown by Mr. Sonko.
Okay, let's speak capacity. You say that it has capacity. Capacity is corroborated by facts, right?
Yes.
What's the current value of the debt?
6.7 million.
Okay. Assuming that the car is not depreciating and is being sold at value, right? So you have your 700. What other ways or alternative sources are there?
Thank you for your question. As you can clearly see under the offer, one of the alternatives we also gave was to compound the 20% stock that Mr. Sonko had in Sonko Limited. And if you go to the pleadings, I think it's exhibit number 3, you can clearly see that we have 6,321,000 shillings, a 20% share in Sonko Limited. So our question is, why was this offer unreasonably rejected by the creditors? And that is what we are seeking to look into the matters before this court.
Had you liquidated that particular stock share at the point they issued your statutory decree? Had you liquidated that amount for purposes of pay?
There was an offer to liquidate. And clearly when we go to Section 20 of the Insolvency Regulations, it states where an offer to compound.
Okay, so one of the issues, or one of the things that is required when a statutory demand is served on you is to liquidate within those 20. One of the things that you're expected to do is to pay the debt within the 21 days. So it's a notice period to pay. So the question is, if he had capacity, because the question here is capacity to be paid, why was it not paid?
Thank you for your question. The reason why it was not paid is because, as you can see in the offer, we clearly indicated that they were to sign their signature as to assent to our offer to liquidate our assets. And as such,
did anything stop your client from selling the stock?
The stock.
Did it require for you to liquidate that particular stock?
There must be consent from both sides of the parties.
My question is, did anything stop Sonko from liquidating his 20% stock with whoever else to pay the debt?
Thank you for your question. The only thing that reasonably stopped our client Sonko from liquidating our assets was an affirmation from the creditors.
Would it have changed that the debt is owed?
It would have absolved the debt.
The debt can only be cleared by money.
Yes.
Right?
Yes.
Not by concurrence. So what stopped Sonko from liquidating his 20% with whoever he wants to sell his share and then pay the debt?
Thank you for your question.
Because my question is, how do we say that this is an actual intention and not fluff? Because surely if you're saying his stocks are worth that much, nothing is stopping him from selling it. He does not need consent from the other party to do so. Oh.
Thank you, but thank you for your question. However, if we go into the depth and the context of the Insolvency Act, when looking at the alternatives to bankruptcy, you can clearly see that the essence of this offer is a two-sided approach. When one makes an offer, there has to be reasonable consent by the other party. For Mr. Sonko was, in that moment, afraid that without the consent from the other party, then there would have been no reasonable way to assure that his assets were going to be used correctly. We must also look at the conduct of the other parties when they were doing this, when we go to the statement of facts. You must clearly see that one of them, Kasuku, was in the petition without having any reasons for being there. Nowhere in the statement of facts does it indicate that she was owed any particular sums of money, and she blackmailed our client. So when we made this offer, we had to take precaution as to the conduct and activities of the debtors.
Very well. Carry on, because I can see you're short on time.
Thank you for your
substantive part.
Thank you for your question,
Yes.
and I'd like to cede the floor to the second speaker.
My name is Good afternoon. My name is Michelle Collins, second counsel to Mr. Sonko. I would like to reiterate on what Co-Counsel Shalom Omondi has established with regards to capacity to pay. And with that, I would like to refer the court, this honorable court, to the case of, in the matter of Alejilo Falen, Insolvency Cause 6 of 2018. It was pointed out within this particular case that the inability to pay a debt should not be taken out of its context, for it may be consistent with a state merely of temporary financial embarrassment or due to commercial insolvency in circumstances where a debtor's liabilities do not exceed the value of his assets. With that regard, I would like to refer the court to what the court in that particular case established with regards to temporary financial embarrassment. We submit before this honorable court that Mr. Sonko, all Mr. Sonko faces before him is temporary financial embarrassment. As established within the case that I just mentioned, it should not be taken out of context. Mr. Sonko on hand has sums of money worth 2.2 million Kenya shillings. But that does not mean that he does not have the capacity or ability to pay his debts. It was equally stated within the same case, to establish insolvency, it must be shown that the debtor's liabilities as a fact exceed his assets, and not merely that they might do so. The petitioners, being the creditors, have not established before this honorable court, or have not shown before this honorable court, that indeed the debtor's liabilities exceed his assets.
Counsel, when did the Lovers' Day event occur?
Thank you, Your Honor, for that question. It occurred on the event was to take place on the 14th of February 2022.
And when did the petitioners got the petition before this honorable court?
They submitted the petition on the 15th of June 2022.
How many months after the event occurred?
Considerably, there were considerable amounts of months.
Around 4 months. Because I want to understand the debtor's position with the temporary financial embarrassment. This was 4 months into the debt. So how is it a financial embarrassment if, for example, Mr. Gold was to be paid on 15th January 2022, Mr. Jimo was to be paid on 1st February 2022, and the Intercontinental Hotel on 20th January 2022.
Thank you, my Lord, for that question. And based on the statement of facts as established, it will be clearly seen that our client, Mr. Sonko, first of all, he was under duress from Ms. Kasuku. First of all, used the money that was meant for the event to buy her a car. Furthermore, within that period, it is equally seen that the wife to Mr. Sonko kept nagging him with regards to the Maldives event that
I didn't expect you to go there because that would lead me to Regulation 32.2 of the Insolvency Regulations. Actually, Section 32.2 of the Insolvency Act that requires that in one of the instruments you need to provide in the affidavit at the statement of the partner's income. We don't have that in your. Is it there?
Yes.
Please read it.
Yes, it is there.
The statement of Mrs. Sonko's income, because maybe the marriage party was sponsored by Mrs. Sonko.
But from the statement of fact, it was all sponsored by Mr. Sonko. In regards to the statement of facts.
Which paragraph?
Paragraph 2.
He's looking through that.
Yes.
Now that you've taken us to how money was spent,
yes.
and I can see we are short on time, so I'm really keen on addressing substantive issues as against the law. Okay? So if I, number one, look at previous behavior in terms of how that money was spent,
Yes.
so it is very clear that the money was actually paid for the event. Right? And then we see that Sonko says that he had argued, so those are the facts, that the event was months away and he still had time to gather his materials to make the event a success. Which then speaks to me on offences in relation to debt, Section 29, particularly on the fact that he was making Russian hazardous. So that's, I want you to address me on, or is there someone else doing offences or it's you?
I will address it.
Yes, good. I'm very keen. If you look at paragraph 2 and 3, as against paragraph 1, 2, 3, 4, 5, 4, how he procured the debt, knowing very well he had spent money that was meant for that event for other things. And then compare that with what Section 29 provides. Would it be fair to state, or would it be lawful to state that it is a contravention or is that liable for the offences that have been provided by the Insolvency Act, Section 289?
Thank you, my lady. And for that, I would like to direct the court to Section 289, subsection 3, which establishes a defense to prove that at the relevant time, the bankrupt had no intention to defraud.
Very well, and I hope you would go there. Yes. So, at the point he's actually then spending this particular money, yes. He says in this last paragraph, he had argued that the month, it was months away, yes. And he still had time to gather his materials to make the event a success. Isn't that speculative? Isn't that's a future statement, it's speculative, yes. That he would have had money.
Yes.
Isn't that hazardous?
Thank you, and I would like to direct the court again to the same paragraph 4, which establishes that it was usual practice between Mr. Sonko and the clients. And so, based on the fact that it was a usual practice between these two parties, there was no intention. There was no, there's no intention that has been proved before this one.
At the point you're reading, thank you.
Yes.
Just because I've seen the time over.
Yes.
So your argument is that there was no intention to defraud.
Yes.
Despite the fact that we can see that he used the money, the 5 million, that was meant for this event for other items.
Yes. And with that regard, Mr. Sonko, it is said that he knew he was going to, he promised to pay, and obviously he would promise to pay because he knew he had the assets based on the first paragraph in the statement of fact.
Was he meant to pay this particular debt by, or these suppliers, was he meant to pay them by assets, or was he meant to pay them with the money that he had been given for this event?
With that regard, it is stated in the first paragraph that Mr. Sonko is a hustler.
Which is not a job description, but my question is, he had been given 5 million for this event.
Yes.
Was, at the point he was contracting this particular supplier, had he kept that money for the suppliers, or had he utilized that particular money for his personal misgivings, as I might put it? Did he have the 5 million that was meant for this event?
Yes, he did have.
Did he have the 5 million? I'm not questioning, it's not a yes or no. I'm just asking, based on the facts. Yes. You said it's a statement of facts. Yes. Did he have it?
And for
did
that,
he have it?
He did not have it.
Okay.
And with that regard, and that is why we are not contending the fact that we do not have that money at that particular point.
So back to section 59. Yes. How are his actions not relating or not? How can I not join them? As someone who's meant to adjudicate this matter, how do I not, or how do I disjoin section 59 with the statement of facts? The statement of facts as presented demonstrate that he engaged in rash and hazardous speculation, which is to say, I'm spending money now, hoping that I'll get some in the future to pay my bills. And justifiable spending. He took some money, in the same 5 million, and took his wife to the Maldives. Took some money, bought a car for us. Right? Is that justifiable spending? And that's what I'm asking you. I'm really keen on seeing how your facts do not relate to section 29 of the Insolvency Act. I just want you to persuade me on that.
It might not be justifiable spending, but at the same time, the adjudication order is not necessarily with regard to how he spent his money. It is with regard to whether or not he has the capability to pay the money.
Okay, so then let's go to capacity.
Yes.
His current job description is hustler.
Well, not necessarily as per the first paragraph.
I'm saying they say he is a CEO of various companies and has always been sought after for his expertise in being a hustler.
Yes.
Okay. So, how does expertise in being a hustler, seeing the only hustle we can see here from the statement of facts was so poorly mismanaged that not only, because the question here is, can he manage his affairs? That's what we talk about when we talk about that someone else should come and manage his affairs. This one event, if you look at the total amount of suppliers in terms of value, it was coming to 6.7 million. He had been paid how much? 5 million. So that should tell you already it's not very good in terms of just financial prudence.
Yes.
Okay. Then his expertise is that of being a hustler. So tell me, someone who, even in the one hustle that you see here, there is financial imprudence, correct? Going for 6.7, it's already a 1.7 million. And then we are seeing his expertise is a hustler. How does this person have capacity to repay debt?
Thank you, Elodie, for that question. With regard to the second paragraph of the statement of facts, it establishes that Mr. Sonko had a creditor by the name of Bonham Kali. He owed Bonham Kali 2 million Kenya shillings, to which Mr. Sonko paid that particular money. And as such, it establishes that Mr. Sonko is an honorable man with regards to the promises or credits that he receives from other creditors, as established with the second paragraph.
So, Mr. Chair, I have one question subject to Seven Judges' concurrence. So, I'm trying to follow your case here. So, lead counsel Mr. Omongi stated that Mr. Sonko had considerable assets which he was willing to liquidate to satisfy the debt. Yes? That is the case. You were asked by the justice why he did not liquidate the sums prior to the case being filed, yes? And there was no sufficient reason given. Yes? So my question is, bearing in mind the ratio of the susmativo in the case of Alifala which you have cited, in the absence of any measures taken by Mr. Sonko to liquidate his assets, satisfy the debt, does it still fall under the category of financial embarrassment?
Thank you, Ola.
Bearing in mind what Matibu said.
If you would please repeat the question.
So the question is, given that Mr. Sonko has not taken any tangible steps to pay the debt, and bearing in mind the case you have cited before this court, does he still fall under the ambit or the protection of financial embarrassment? Or is it just a smokescreen in his direct record?
Thank you, Your Honor. Thank you, my Lord. And to that I would say, based on the fact that he did not liquidate his assets, then it would be sufficient to say that indeed it does fall under the same temporary financial embarrassment.
Okay, going back to your submissions, you have cited the case of Flower City Limited versus Pollutants, if I'm not wrong. At paragraph 23. Have you not? If I'm wrong.
Please repeat the question.
So, you've led in the case of Flower City Limited, yes?
Yes.
So, in that case, one of the requirements is that the debtor must demonstrate all attempts to pay the debt were made. Yes? So, in the absence of any attempt to liquidate the assets, is it therefore Mr. Sonko liable for not paying his debts?
Well, the answer to that question would be the fact that he did not liquidate his assets because of the fear of the precaution of Ms. Kasupu. Ms. Kasupu is within this petition, and as we will submit, she should not be within this particular petition as a petition. And as such, my client, Mr. Sonko, will not liquidate his assets. And furthermore, an offer was indeed sent, just as co-counsel Shalom Mundi had stated earlier. And that was to show his willingness to pay this particular debt. For the purposes of time, I would like to cede the seat to co-counsel.
Thank you. My name is Caroline Ebony. If it will please, this is what it's not an issue per se. It's kind of my trials. Where a debtor is a natural person, Part 4 of the Insolvency Act provides for alternatives to bankruptcy. This was reiterated in the case of General versus Chu. This court should not adjudge my client as bankrupt because in the case of Chumi Supermarkets PLC versus Itonguri Dairy Farmers, we have 4 alternatives to bankruptcy, which are set out in Section 14 of the Insolvency Act. You have voluntary agreement, proposal, no asset procedure, and payment to the creditors in installments. So you should not have done this bankrupt. You also have other prayers. We'd like this court to declare a stay of proceedings in the matter on the grounds that the matter is subjudice in the principal magistrate's court. Number 2, decline to grant a bankruptcy order against the debtor, as the debtor has the capacity to pay, as my co-counsel has stated. Number 3, direct that the alleged debt be subjected to investigation and adjudication with the criminal justice system, and dismiss the application for a bankruptcy order until the criminal investigation is concluded. Number 4, strike off the 6th petitioner from the petition says the debt is not yet due for payment. Number 5, dismiss the application for a bankruptcy order if it is found that the debtor has made an offer to pay off their debts, which have been unreasonably refused by the creditor. I cede the floor back to you.
Counsel, I have a few questions for you. You've given us your prayers. In your arguments, I see that you're saying that one of the reasons why we should not adjudge Sonko as bankrupt is because there is an ongoing criminal case. Supposing, for argument's sake, the bench were to buy your argument and we strike out the name of Kasupu. Remember, we have about 6 or 7 creditors, isn't it? So how does that argument hold in contrast to the other creditors? So if we remove Kasupu, where does that leave us? Do you want us to merely dismiss the bankruptcy petition on account of an ongoing criminal case, yet there are other creditors?
Thank you for your question. Number 1, I'd like to advise he who comes to a
liability must come through.
That's a good answer. Yeah, and I appreciate it. But yes, Kasupu has come with tainted hands. What about the others? Do you want that argument to help you dismiss the bankruptcy petition as against the other 6 creditors? Yes. And as you chew on that, you've also told us that you want us to dismiss the bankruptcy petition, and you've given us a raft of reasons why. I want to take you back to section 289, which my sister judge went through with one Mr. Collins extensively. It gives several reasons, isn't it? It talks about bankruptcy offenses, and one of them is living extravagantly. When did Mr. Sonko travel with Mrs. Sonko to the Maldives? It was on the 5th January 2022. Yeah. In your view, and I'm sure the other side raised it, wasn't that a bankruptcy offense?
No, it's not.
Why? Please explain that to me.
According to section 289.3, there was no intention to defraud. For intention to suffice, there has to be an extra. And my co-counsel.
It's okay. Anyway, time is over, but I thank you for your answer.
Maybe because they have a right of response, what are your prayers with regards to Kasupu's petition?
My prayer is that Kasupu be struck from the petition because there's no credible evidence. We're looking at the statement of facts that she is owed any money, and we believe that she is adjoined to the petition on the grounds of bad faith, looking at her previous conduct. That is our prayers.
Is something wanted to say?
We're making
is their time up?
We were making individual submissions, so I don't know how to respond.
My Lord, I think we were given 5 minutes for
quick fast tools. Think on your feet.
Yes.
That's what he had introduced.
I'm objecting under the I think 2023 bankruptcy rules.
You also have a chance to respond.
Okay. Thank
you. Quick fire to think on your feet, right? It's just a new trial that Lennox had introduced.
May it please the court, my name is Peter Magoba. I'll be brief on one issue so that my co-counsel can handle the other issue. The first one is my opposing counsel said that they have the capacity to pay, and my other co-counsel, opposing counsel, said that that Mr. Sonko did not spend his money. He did not spend his money carelessly, thus he did not commit a bankruptcy offense. My lords, if I take your attention to section 289 of the Insolvency Act, which clearly states that a debtor commits a bankruptcy offense in bankruptcy if his acts materially contributed to increasing the extent of his or her insolvency. My lords, I'll direct you to the statement of facts. Paragraph 3. Sonko again dug deep into the kit money given by Kusota and bought a VIT. My lord, if I may ask, does this not materially contribute to spending money that was meant for other businesses? That's the first thing. The second thing, he claimed that they have a 20% share in the companies, which they never liquidated. What is the work of a statutory demand? It gives them edible time, 21 days, to liquidate their assets and pay us money.
Counsel, yes. I'd like to ask you a question. You've said that Section 289 talks about whether the bankrupt has materially contributed to.
Yes.
I want us to look at the proviso, which is under subsection 3.
Yes.
Was there any intention to defraud in this case? What's to say that Mr. Sonko is just a financially imprudent person who just makes bad financial decisions, but he had no intention to defraud?
Thank you, my lord. If I may direct you to statement of facts, paragraph 4 clearly says that he therefore contacted his suppliers who largely constituted of his personal friends engaged in event organizing and the management. My lords, if I may also direct you to paragraph 1, what was the intention of this man? Business. What did he do? He dug deep to buy a Vitska for the mistress, my lord.
Okay, proceed.
Let me, okay. So you say he dug deep and bought a wig for his girlfriend, right? So this is clearly someone who honors their wife. Whether it's with someone like Mkali, Bona Mkali,
yes,
he repaid his debt. When he comes to his girlfriend, he repaid his debt and bought her wig. So he has past behavior of performance in terms of debt.
Yes.
So then, why would we declare this person bankrupt?
My lady Justice, if I may direct you to the same statement of facts, paragraph 4, he specifically promised to pay this debt within the dates aligned. But my lady, even after serving them a statutory demand, they did not comply. So this man is not true to his word.
Okay. But he's if we can say he honors his promises. The issue of the dates aside, he honored his promises with two different parties, different statements of fact.
Yes.
So is a delay, a 4-month delay, sufficient for us to adjudge someone bankrupt? Is it just for us to adjudge someone bankrupt if he has past performance or repayment?
My lady, if you are looking at the timeline, the creditor Bwana Mkali he owed him before he owed this other debt.
But you see, what bothers me is that also the statement of fact says, turned out that Kasupu in cahoots or cohorts with friends listed above. So
yes.
first, these are his friends.
Yes.
But this is something that has been instigated by Kasupu.
Yes.
I'm assuming now no longer his current girlfriend, but former girlfriend.
Yes.
So, yeah, malice.
My lord, my lady, there is no malice there. As you could clearly see from our our submissions. In our submissions, Kasupu is enlisted as a witness who is crucial in this case because Kasupu was a confidant.
Is a witness a petitioner?
No, my lady.
So she has not been.
She's enlisted as a witness.
Okay, very good. Secondly, I don't know whether it's second, but the twin goals of bankruptcy
yes.
is 1, protect the creditor.
Yes.
2, a fresh start for the bankrupt.
Yes.
Right? For the person to be a judge. Now, if then you're thinking of protecting yourself, and his expertise is being a hassle.
Yes.
To the extent, and the only thing he did is that he bungled the one event.
Yes.
Until really shooting yourself on the foot. Because this is someone who can actually hustle another event, get another 5 million, because his habit is to get money from, yes?
Yes.
You wanted to interrupt?
Help you.
Oh, well, that's your private arrangement. Very well. His expertise is hustling, correct? Now, if you get a receiver who manages affairs, it means you're basically bringing his hustle to a grinding halt. How does this then protect you as creditors? Wouldn't it be better, dare I say, perhaps more just to let him hustle, agree to his offer of settlement, and then we come back when he has actually, as opposed to actually judging him bankrupt at this stage.
My lady, as my co-counsel clearly submitted, that
Maybe a question to colleagues.
Yes.
Are you aware of the incapacities that you be subjecting the debtor when he is adjudged bankrupt?
Yes, I am aware of the incapacities that may follow the debtor once being adjudged bankrupt. One such incapacity is that he may not be able to continue with the businesses that he has. He may not also be sorry, my lords. The tools of trade that he has, he may remain with the tools of trade that he has, but the businesses that he may not be able to continue the businesses that he has. I shall be making submissions in regards, or rather rebuttals, in regards to certain statements that have been made by the debtors' counsel. The debtor submits that this court does not have jurisdiction to entertain this matter, merely by the fact that there is no evidence of leave of court for them to come to this court. The question that we need to ask ourselves is that should the court then move to the bankrupt to the magistrate court to entertain this matter? The answer is no. We have submitted in our opening remarks that as per section 17.2, there is the word the court. Section 3 defines the court as the High Court, and by that regard we are here today, my lord. So, my lord, the counsel to Sonko have also submitted that.
Before you go to that, what is the fate of the case in the magistrate court?
My lord, we submit that there is no case in the magistrate court, and it's because that is why we are here today.
Counsel, is the case still existing?
No, the case does not exist.
Why does it not exist? Is it that
Objection to.
Please allow him to finish. Counsel, what do you mean when you say that the case is not existing? Was it withdrawn? Was it struck out? Was it transferred?
My lords, the case was never submitted to court in the first instance.
So
we had served them with the pleadings in regards to the magistrate court, but we had not served the court with those pleadings. After realizing that indeed this case ought to be taken to the High Court, we served them with fresh pleadings in regards to the High Court and submitted to the High Court, to the bench here today, those proceedings of the High Court. So there is no proceedings that were submitted to the magistrate court in the first instance.
Okay.
Yes. My lord, secondly, the counsel to Sonko have also said that they are not debtor and we are here only to shame them before the court. And thus then they appear that they are able to pay the debts, merely that they sent an offer and the offer was rejected. My lords, it appears that inability to pay the debt by the meaning of section 17.3 tells us that one, the statutory demand that we had served them must have elapsed by 21 days, and two, the debtor did not comply with that statutory demand or did not apply to the court to set aside that statutory demand. We are relying on this section, my lord. They did not comply with the statutory demand. The mere fact that they sent a letter stating that indeed they offer to send, they offer to send the money to us, my lord. The statement of facts, they are friends. He knows the account numbers of the creditors and is at a capacity to send these monies to the creditors. Secondly, my lord, he did not apply to the court for this statutory demand to be set aside. My lord, the counsel to the debtor has also stated that indeed they are a capacity to pay the debts through the so-called limited and the assets that they have. My lord, we submit.
We have been all times now. I think your colleague has something to say as well.
Yes.
Do you mind in 30 seconds, wind up what you were saying.
Yes, I'll just wind up with one.
Want to donate it to your colleagues, your time.
I'll just mention one.
Okay.
They say that there is a charge sheet for Kasupu in the criminal court. My Lord, we submit that a charge sheet is not prima facie evidence to show that someone is indeed of bad character. Thank you. I see the flip.
Much obliged. Hello, my ladies. Just to reiterate on what my fellow counsel were trying to submit in regards to the statement made by my lady on Sonko having been able to honor his debt. However, we submit that yes, he has the habit of keeping his promises and paying the debt as he promises. However, his business is not stable in the sense that he borrows money to pay money and borrows money again to pay another money. That is not a good sign of a stable business, and therefore more creditors will suffer. And my lord and my ladies, it's in the interest of justice that the court makes a decision that will be able to protect the public interest at large. The other emphasis is on what my lord had said, that it may not be fair and equitable to a judge bankrupt because of the repercussions of one being a judge bankrupt. However, my lord and my ladies, bankruptcy offers protection to a debtor. That is, he's allowed to retain his tools of trade and to retain a reasonable income that is sufficient for his own upkeep and that of his family. And that is protection enough. However, if we allow him to go away scot-free, borrowing money to pay money, borrowing money to pay money, then more people will suffer. And yes, bankruptcy is a tool. It's not a badge of shame. Thank you.
Okay, and then I'll just pick up on what I was addressing before.
Yes.
When we were arguing about, when I told you about the three principles of bankruptcy, where you say one of them is to protect the public. And my brother Jack then followed it up with incapacities that come with being declared bankrupt. And my question then back to you, which I asked you, don't you think it is unjust to declare so-called bankrupt, yet he has such great expertise that is actually even sought after as a hustler? Meaning, not only can he hustle his way out of this situation, but he can also find another event for which another event, possibly the next year's Lovers event. And then the same thing we did with Wanamkani, the same thing we will do with him. But to have him declared bankrupt because of one event, all these petitioners are coming from one event, right? It's not petitioners from different.
We have other creditors, possible creditors, because he only accepted part of his liabilities, and that is including his stamp card.
So exactly. So let's talk about the statement of facts.
Yes.
So the petitioners all arise from one particular event. So this is to show, despite the fact that you advertised and then you filed your petition assuming you advertised, no one else came up and said that indeed this person does not pay them. So it's one event that just went wrong. Is that sufficient to have this person deprived of his livelihood, so to speak? And his livelihood, by that I mean being a hustler of several companies. Is it enough for us to then say he should be declared bankrupt? Is it just? That's my question.
Now, yes, much obliged, my lady, and thank you for the question. Now, Mr. Sonko has a debt which amounts to 6.7 million. And this is a lot of money. And yes, it might be one event. However, if he gets another hustle and pays the money, and then gets another goods on credit, then I believe that is not a stable business. And it won't be equitable to creditors. Furthermore, his actions of not paying the debts when due amounts to a breach of contract. And yes, he might walk away from not being a judge bankrupt. However, he'll suffer civil sentence because the other creditors that he'll be getting money from will always pursue him to demand for their money. And
so are you here to protect future creditors, or are you here to focus on your debt?
Yeah, we are here to focus on our debt.
Then focus on the question then is, Why declare him bankrupt? And that's what I'm asking.
Because he has no capacity to settle his debts.
But he has capacity as a sought after expert, has he?
It's not premised on a stable business. That is our argument.
So what is in contention? Is it the stability of Mr. Sonic's businesses or his ability to pay his creditors?
His ability to pay.
Exactly.
Yeah, and we have also, from our presentation, we've shown this court that he has no capacity or reasonable prospect to settle his debt.
Based on what?
Based on the statement of affairs that we were served, based on the bank statement, which was fraudulent and showed that he did not have sufficient money in his account.
Just following Sister Jack's question, was there a reasonable offer made to the creditors that was denied?
No. My lord and my ladies, in as much as the offer was denied or rejected, then he had the option, by virtue of Regulation 16 and Regulation 17, to go to court and set aside the statutory demand. And the court will then make a decision in which both the creditors and the debtor ought to comply with it. Thank you.
Now, in the interest of time, I'll probably just give questions to each member of the bench. You can ask just one question to either side. As we, sorry?
One more. And then. Can we do rebuttals?
No, it's only the petitioners who have the right to rebut.
We don't have a right of reply.
Well, it will be a shouting match.
Okay. Maybe the other things are now changing. This one can be made.
the defaulting party, or rather, my apologies, if one party defaulted, the party that was, they would send a written notice to the defaulting party so that if when we did not pay, when the dates came due, we were to receive a default notice. I would also like to say, alert this court that we did not receive any default notice whatsoever. Immediately after we defaulted payment process, as they alleged, we shortly received a statutory demand, demanding us to pay the debts to all the creditors, and as which we responded with an application to set aside. And furthermore, with regards to contestation of the debt, one of the reasons why we went to rose the application was we contested some of the amount of money because our creditors are not furnished us proof of debt. We were not received an invoice to show that the goods that we received were of a particular amount. For example, if I'm to highlight one particular creditor, we have Miss Scotch. She was to deliver. Flowers, and in this particular situation, we received flowers, not flowers, apologies. She was to deliver.
Miss Good was to deliver drinks.
Yes, my apologies. She was to deliver drinks, and she did not furnish us proof of that they were worth the amount that she was delivering, which was $1,000. We did not receive an invoice from Miss Scotch proving that amount. That was one of the few, because of the grounds we set up when we raised this application to set aside the statutory demand. In addition, I'd like to quote section 17.6 of the Insolvency Regulation, which provides that if one can raise a genuine dispute, then a statutory application needs to be set aside. And one of those grounds would be that the debtor appears to have a contact claim to settle or a cross demand which equals or exceeds the debt owed. The debt dispute, section B says that the debt disputed was grounds which appear to be substantial before the court. And lastly, that in particular, section D, which says that the court is satisfied on other grounds that the debt ought to be set aside. As well, we made reliance to the case of Flower City Limited versus Polytanks and Containers Limited, 2021, in which the court affirmed that when a debtor claimed to have a contract claim within the meaning of 1766, the court would normally set aside such claim if, in the court's opinion, there was a general tribal issue. We believe in our submissions in the ground set before you raise the general tribal issue, and thus we request the court to set aside the such claim.
Counsel, you talked about a default notice.
Yes.
A default clause that was in the contract. What is before this court? Is it a case of breach of contract or bankruptcy?
Why we raised the issue of breach of contract was that we believe, or rather if the respondents believe, that we should, a petition to the bankruptcy petition should not have been filed. The whole point of my understanding of a contract, when you bind yourself, two parties bind themselves to a contract, the first course of action should be within the terms of the contract, which is the notice of default before being given a statutory demand. And even if we respond with an application set aside, the creditor still file the petition for this court.
Please speak louder.
Yes.
And when the substance of the petition, we will make a determination on that preliminary objection or application in the course of argument.
I understand.
Just on the same matter, the one big quoted was brought for failing to supply the invoice. Should the 1 million be removed from the 6.7 million, does the counterclaim of the debtor equal or exceed what the creditors are asking? You have said under Regulation 17.6 where the debtor raises a counterclaim of account 1 that equals or exceeds that, then this court can set aside the statutory demand. And in giving us that direction, we have only highlighted Ms. Lodge who was to supply drinks at an event and failed to furnish the debtors with the invoice. Now, we are doing a rough mathematics here. 6.7 million plus 1 million equals how much, Council?
5.7 million.
Does that equal or exceed in any way the amount that the creditors are seeking?
In addition to that, I'd also like to quote the character of
Mr. Ted Josiah, because his debt has yet to be
Just to
disposed.
proceed as
So, to proceed, I'd like to invite the council.
Council, speak loud so that it can be picked up.
May it please this honorable court, my name is Yvonne Margaret. The second counsel for the respondent, and I will be tackling issues of procedural deficiencies in the part of the applicant. I would first like to proceed by quoting the words of Judge Batigo in the case of Ali Jigo Fana, in which he said, a bankruptcy petition triggers judicial scrutiny into the merits of the petition in conformity with substantive laws and regulations. I would like for this honorable court to take this into consideration.
Was it an auditor or a racial incidental counsel?
An auditor.
It was unrated from this side that it was an ratio. It was an auditor. Okay, proceed.
First of all, I would like to highlight that the statutory demand that was served upon us was defective in both form and substance. Regulation 15 subsection 3 of Regulation 15 subsection 3 of the Insolvency Regulation provides that a petition ought to be preceded by a statutory demand as set out in Form 6 of the first schedule. We also rely on the stipulations as to the requirements on a statutory demand as per Houseberry's Laws of England. And as per Houseberry's Laws of England, and some of the stipulations that are provided include that the demand ought to be drawn and filed in court by a form of advocate, and it should be filled by the Registrar of the High Court. The statutory demand should contain an explanation to the debtor on the purpose of the demand and the consequences for failing to comply within stipulated time that bankruptcy proceedings will follow, and it should explain the period of time and the manner in which the demand has to be complied with, and the statutory demand should include the details of the creditor. Yeah. The statutory demand, I will also rely on the case of Resikasa at Mombasa Road Limited, a 2019 case, where it was held that a statutory demand may be rescinded if the creditor failed to use the correct form and or required method of service. And we'd like to present before this honorable court that the statutory demand that was served upon us, served on the 8th of May of the year 2022, did not include the amount of debt which our client was expected to pay to the applicant. It did not specify each of the amount of debt owed by us and to the creditors. I will also proceed to focus on the matter of timeline. The applicants in their application for this petition failed to comply with the timeline stipulated in Section 17, subsection 3 of the Insolvency Act that prescribed that 21 days have to have elapsed since the statutory demand was served upon the respondent was served upon the debtor before a petition was filed in the court. In the case of Flower City Limited versus Polytanks and Containers Kenya Limited, it was held that if a debtor did not comply with a demand within the stipulated time, he was deemed unable to meet his debts, and bankruptcy application can be brought against him. The petition before this court, a statutory demand was served upon us on the 8th of May, the year 2022, and the petition before this honorable court was filed on the 15th of May, barely a week after the statutory demand was served upon us. We were not offered a chance to respond to the statutory demand or for any other alternative routes to be accorded to us to settle our debts with the applicants. I will also go to Section 17, subsection 4 of the Insolvency Act that prescribes that the creditor, in case of a bankruptcy application, the applicant has to serve a demand requiring the debtor to establish to the satisfaction of the creditor that there is reasonable prospect that he will be able to pay when the debts fall due. In the matter of Ted Josiah, our debt is due in the month of August, yet this petition was filed in the month of May, and there was no such demand that was served upon us to provide, to establish to the applicant that we can settle such a debt. And I will also refer to the case of Lupton Kenya Limited, where the Honorable Justice pronounced that a respondent ought to be given a chance to prove he can settle his debts or otherwise before before a petition is executed against him. My lords and my ladies, I would like to refer to Section 25, subsection 2 of the Insolvency Act that provides that a court may refuse to adjudge a debtor bankrupt if the debtor failed to comply with the requirements specified in Section 17. Also, I refer in Section 25, subsection 2 as well, that a court may refuse to adjudge a debtor bankrupt if the debtor is able to pay the debt, or if it is just and equitable that the court should not make the order. As per Section 16, subsection 2, the court may dismiss such a bankruptcy application if it is of the opinion that a requirement in the Act or its regulations has not been complied with. I have proven what I believe to be beyond doubt, that the applicants, in their hurried attempt at coercing our client to repay a debt which he disputes, issued this petition against us. And I will conclude relying on the pronouncement in Republic versus Immigration Appeal Tribunal, ex parte Jaya Station, a case of 1999, where it was held that procedural requirements are designed to further the interest of justice. And any consequences which would achieve a result contrary to this interest should be treated with considerable caution. And as per this pronouncement, I pray to this Honorable Court that this petition be dismissed against our client, as the applicants failed to fully comply with the stipulations in both the regulations and the Insolvency Act of 2018.
What's the burden of proof in such a matter?
The burden of proof. I believe it is upon us to prove the deficiencies in the applicant in stating their case.
And the standard of proof?
It's
balance of proof.
Thank you.
Counsel, a question. You said that you spoke about something procedural. You said that they came to court hurriedly.
Yes.
Before the 21 days had lapsed.
Yes.
Was that your submission?
It is our submission.
Okay. Is a statutory notice a bar to filing a petition, or is it a bar to making a bankruptcy order?
Is a statutory.
Maybe let me rephrase the question. Is a statutory notice, does a statutory notice prevent you from filing a petition in court? Can I issue a statutory notice today? If I issue a statutory notice today, do I have to wait for the 21 days to lapse?
Yes, I believe that the recommendations provided in both the Acts and the regulations are not a suggestion, but rather procedure that has to be fully complied with. And the 21 days are meant to provide an opportunity for the debtor to fully respond to the demands of the creditor. So I do believe they are not really a suggestion.
Are you aware of the provisions of Section 20, subsection 2, which I may read for you, which says that the court may not make a bankruptcy order until at least 21 days have lapsed since the service of the relevant statutory demand. So my question to you was, is a statutory notice a bar to filing a petition, or is it a bar to making a bankruptcy order? Say 21 days have lapsed now. We are assuming, I don't have the fact pattern for your particular petition. Let's assume the 21 days have already lapsed after filing, after the petition has been filed. Should the court issue a bankruptcy order? Should the court adjudge Mr. Sonko as bankrupt or not bankrupt? After those 21 days have lapsed after filing the case in court?
I believe that if the petition was filed prematurely, in compliance with the necessary procedural requirements, then the matter should be dismissed.
Okay, so for you, a statutory notice, 21 days have to lapse before we go to court?
Yes, I need a bit of a procedural period time.
Okay, proceed.
Still on procedure. Article 159 says that we should focus on substantive justice and not procedural technicalities. Right?
But I believe that if we were to focus on sorry.
Yes, so that is what that provides, and that is the constitutional provision.
Yes.
Above all, supreme law.
Yes.
Now, would it be prudent for this court to focus on procedural technicalities and abandon the perhaps very valid claim that have been placed here by the petitioner based on issues to do with procedures?
I believe that if we were to not follow due procedure in such a case, it would be prejudicial to our clients and it would not be in the interest of justice.
What prejudice do you see?
He was not given adequate time to respond to the statutory demand.
Has he paid currently?
No, he has not.
So was time the problem?
But in our submission, our client contests the debts that were presented to him.
Part of the debt?
Yes.
So is the undisputed part of the debt paid? No. Yet your argument is that you ought to have been given time to redeem the debt.
Yes.
Right? And the equity of redemption, your equity of redemption has been curtailed by dint of the fact that they did not issue you with a statutory demand.
Yes.
So the question here, it really truly boils down to time.
Yes. But
okay. Now, I remember my brother judge had stated the period within which the debtors, the creditors were expected to pay. Right? 4 months, correct?
Yes.
And then the petition was filed in June. So between January, Feb, June, we are talking about 4 to 5 months or there. Right?
Yes.
Not within that period, the disputed and undisputed debt has not been paid. And yes, your argument to the court is, forget the substance of the petition. Focus on the fact that they did not issue us with a notice to do that which we ought to have done.
Yes.
So that is your argument. Look, you can confidently say yes. Correct?
Yes.
Okay.
I believe we have due procedure in place for a reason, and the law, if we were to each prescribe the law to our conditions differently, then it would really not be the law.
So if I'm balancing the prejudice suffered by the debtor versus the prejudice suffered by the petitioner creditor. Remember he talked about balance of probabilities. Let's talk about scale of justice in that balance. Who is more prejudiced? Or you are?
Yes.
Because 21 days would change the circumstances. Very well.
I believe the results, the consequences of being a judge bankrupt would be very prejudicial to our client.
And if he's that concerned about being a judge bankrupt, what's the problem? Why is he not paying the debt that he does not dispute?
That is why we were requesting the 21 days to not only pay the debt, but for the contested debt, we could arrange something other than
arrange something.
We could have an arrangement with the applicant. That is all.
Thank you so much. We can go to the last.
My lords and my lady, good afternoon. My name is Michelle Kelly, co-counsel of the respondent, our clients, who is also the debtor in this insolvency matter before the courts. To sum up on what my fellow co-counsels have stated, the respondent contends that he is solvent on the basis of the earlier submissions and the evidence adduced as the list of exhibits, which provide for the bank statements and proof of ownership and some of the assets that he has, which are more than the liabilities accounted for. In taking into account all the submissions, I'll be making reference to the case of Samuel Kazungu Kambi, number 18 of 2019. The court, in giving effect to a petition for a bankruptcy order, ought to take into account the business realities of the situation and avoid taking a narrow legalistic view that a debtor is faced with certain situations should be declared bankrupt.
Just say that again. Just say that again.
Repeat.
Should not take up narrow
legalistic view that because a debtor is faced with certain situations, it should be declared bankrupt. We got into a contract with the petitioners. We had a breach of the contracts, and in addition to that, there was delay in payment of the debts. That should not have led to straight away filing an insolvency petition to the High Court, but instead we should have come up with better ways to solve the issue at hand and to see whether we can come up with means to resolve the debt at hand.
And so what were the better ways you would have explored?
We could have gotten, the respondent could have gotten to an arrangement with the petitioners to ask for more time, to allow for the respondents to come up with sums to pay the debtors.
Time was the issue here, because essentially this event occurred in February. The petition was filed in June, as the sister judge has said, 4 to 5 months paying the debt. So I'm so much interested in the alternative as well.
Basically, the respondent did not pay the debt even with the amount of time that they were given because they were disputing the debts. These were different creditors that the respondent had different contracts with each of these different creditors, and thus all these creditors just decided to go to the same lawyer and all file an insolvency petition. But we could have decided to use other alternative measures for the advantage of both the creditors and us as the respondents. Basically, also in another case, paying a debt should not be taken out of its context because, as it may be consistent with the state, merely of temporary financial embarrassment or due to commercial insolvency in circumstances where a debtor's liabilities do not exceed value of his assets. As I earlier mentioned, inconsistent to the evidence adduced from our earlier submissions as a list of exhibits, and also pursuant to section 25 of the Insolvency Act, a debtor if a debtor is able to pay the debt, basically if his assets are more than the liabilities, it should be a ground as to which, in interest of time, it should be a ground as to which the petition should be dismissed. Also, pursuant to section 289, subsection 3, our respondent did not have the intention to defraud any of the creditors, and therefore it should also be taken into consideration by this Honorable Court as a ground as to which this petition should be dismissed. The goals of bankruptcy are to protect the creditor and to give a fresh start for the debtor. These are the twin goals as provided by the Insolvency Act in association with the insolvency regulations. And thus, it is the respondent's prayers that this petition be dismissed pursuant to the evidence adduced, pursuant to the insolvency regulations, and pursuant to the Insolvency Act. And that they should not be declared bankrupt, however, be given a chance to be able to repay their debts and as a way to resolve the matter at hand.
Maybe just one question to any of you.
Yes.
I haven't seen, I did not have the benefit of looking at the applications that you filed, but just generally, I saw from the other team the applications that they had filed. And just from general knowledge of law, what is the effect of failure to commission an affidavit that is attached to an application in a case? Failure to commission an affidavit, does it have an effect on an application that has been filed?
it does not have an effect on an application because an affidavit should be commissioned when it is brought, before an application is brought to the courts.
So what's the effect of lack of commissioning?
Such documents cannot be produced before the court.
So what's the effect on the application that has been filed?
The application is null.
Fine. In the interest of time, I don't know how.
I just have one more question. So when you are putting Samuel against a Kambi, you say that we should not have a narrow and realistic view, but we should take into account business reality, correct? What business realities of Mr. Sonko did you want us to take into account?
That is the hustle.
No, that is only, that is the business reality? What does that mean?
The reality is the reality of the issue, or even in real life, we all have debts, we all will find out ways to pay the debts. But the respondent, Mr. Sonko, has shown that he will be able to pay his debts because he also was able to buy Kasuku Avids and he was able to repay his debts, which showed that he is not incapable of repaying his debts. He just needs a little bit more time and a little bit more patience from the creditors.
So back to my question. Just stick to the statement of facts. So I would assume business reality means during COVID, business will not be well. That's business reality. So when I just want to understand what was the rationale of quoting that particular precedent as against your statement of facts?
Because as it has been stated in the facts, Kasuku did not have the clear and the right intentions towards our client, and thus I will not speak for him, but I will appear for him. I'll say that that whole situation made him.
Is business reality taking you out to the Maldives? Is business reality buying a girlfriend a bit? Is business reality taking money that is meant for John to be in Navy?
No, but business reality could be the fact
I'm asking you, just hold on.
Oh.
Are those business realities?
No, they are not.
Okay. No, that's okay.
Counsel, I'll make my question very brief. I'm still on narrow legalistic view as held in the authority. What do you mean by narrow legalistic view? Is it possibly, just maybe explain it to me.
A narrow legalistic view in this, I used this specific case because I felt that the respondent could relate to this specific context, as my fellow co-counsel stated. This was a breach of contract with different creditors.
What does it actually mean to take a narrow legalistic view?
Other approaches could have been used instead of filing an insolvency petition right away.
If the petitioners were to come here and accuse you of approaching this court with a very narrow legalistic view, what would be your response? Because you told us, your colleague Mombi told us that this petition was filed before the lapse of 21 days. In my view, that is a procedural issue. So, what's to say for them to come and tell you, you're approaching this matter from a narrow legalistic view because you're telling the court, don't look at the elephant in the room. Don't look at this huge debt that we owe. Focus on these 21 days. That's where the case is. What would be a response to that argument?
It is our defense.
Okay.
No further. Thank you.
How will you share your time?
Yes?
How
Yes.
will you share your time?
I will use 1 minute, you use 2 minutes, and you use 2.
Oh, one. Okay.
5.
1, 2, 2.
1, 2, 2. Yes, 1, 2, 2. If you may please the court, I may put it on record. They claim that this suit was filed on 15th of May 2022. That is wrong. It was filed on the 15th of June 2022. 38 days. 38 days. They had 38 days to respond, but they didn't. Just that clarification. Yes, greeting once more. The issue of Ted Josiah is a very contentious issue in this court, and the data rather has made mention that by the mere fact that Ted Josiah is part of this case, that this case then is fallible. We are of a different opinion, and we are guided by Section 2 and Section 17 of the Insolvency Act. Section 2 gives the definition of who a creditor is as a person who is entitled to enforce child judgment or a final order. My lords, upon the data, Mr. Sonko being a judge bankrupt, Ted Josiah is entitled to enforce this final judgment. Secondly, my lord, the respondents have made mention of Section 25 in regards to when a bankruptcy order, or rather a bankruptcy petition, may be set aside. We submit to this court that Section 25 does not speak to that fact. It speaks to a trustee's final statement of receipt and payment. Section 20 tells us when a court may actually set aside a petition. Further, my lord, we submit that we are not here, my lord, on a point of malice, but we are here to give them a fresh start. And these are guided by the case of Maina Kabatha, my lord. And in answering the question, my lord, that had been put earlier by Judge Sospita, the debtors are being given a fresh start. And in consideration then, the consequences that may actually follow is that it may only be restricted to actually hold public office, it may be restricted to travel, conduct business activities, and even and his assets, it may lose control of his assets, as these assets may be given to either the official receiver or the bankruptcy trustee. I see the floor to my co-counsel.
For how long is that incapacity to persist?
My lords, it depends on the timing, but upon the creditor applying to court that indeed they have actually paid all the debts that they are due, then that incapacity subsists. Thank you.
Thank you, my lord, ladies. I'll address the issue of procedural technicalities that was raised. So first of all, I'll rely on Article 159(2)(d) of the Constitution, which states that justice shall be served without undue regard to procedural technicalities. I'll also refer this court to the case of Ray James Maina Kabatha, whereby issues were raised as to the procedural technicalities in the sense that the statement of affairs had not complied with the insolvency regulation as to form and structure. My lord and my ladies, the court in its holding, in fact, referred to this objection as a dramatization of the omissions by Stanbic Bank. However, it went on ahead and said that it is only in the interest of justice that the debtor be given an opportunity to be heard and listened to in regards to his petition. Therefore, I believe that the issue of procedural technicalities should not bar this court from listening to our petition. Thank you.
Right. I don't know if there is any question from the bench. Either side, as we wind up.
This question goes to Diana.
Yes.
On your final point on Article 59. Yes. So is it a blanket rule to cover all technicalities?
No, it's not a blanket rule. In fact, in the case of Peter Munga, the court held that...
so which court? High Court?
High Court.
Okay, so I'll refer you to a decision. I know you don't have it. Yes. Two decisions. Samuel Bachare versus KCB, it's a Supreme Court decision, as well as Hanka versus Elfoy, three decisions. Where in both instances the court said that what does not offer blanket protection, the parties must not follow procedure. So the debtor is saying that she should have followed procedure by first issuing the demand and then subsequently filing the petition. So my question is that failure to Regulation 15 and the timeline there are fatal to the case?
Sorry, please.
So is the failure to adhere to procedure covered by 159? Is it something which the court should overlook?
My lord, I'll rely on the case of Zakaria Okoth Obado versus Edward Akongo Ayugi, which the court The Supreme Court of Kenya held that, be that as it may, the essence of Article 159(2)(d) is that a court should not allow the prescriptions of procedure and form to overshadow the primary object of dispensing substantive justice to the parties. Thank you.
So, thank you, ladies and gentlemen. We have come to a close of that session, and we are grateful for your time, for the display of your knowledge in various fields. We'll retreat to make our decision, which will later be communicated to you. You know, those decisions that we have to make here and now, that we do, but on the decision as to whether your judge hustler, the song with the hustler, bankrupt or not, we will revert. It will give us some time to give a reasoned decision. But for the other decisions that we have to make, decision. Those we will make here now before we leave. Up to that point, let me hand over back to
just a small catch-up of housekeeping, and then we'll finish from here, okay? So basically, what was happening in the exercise of Tuesday and today was just to give you let's conclude and then we remove the live recording. So thank you for coming today. I'm just doing it for the video. We're going to say another vote of thanks later. So thank you for coming today. I'm sure there's some of you on this side and the others on that side as well. I'm very grateful. At least I hope it's been an enlightening experience for you. This is from Jkuat School of Law, and we hope to see you again the next time. Thank you very much. Yeah. So we can finish. I think we can give ourselves. The only thing remaining is I just want, based on what has been presented today, is to give you ideas.